Assalamualaikum and good day, Doctor. Before we start the presentation, I would like to introduce our group members. For the first presenter, Nur Huda binti Jaafar with metric number 280535. For the second presenter, Nur Shazwani binti Muhammad Nizam with metric number 280598. For the third presenter, Nurul Huda binti Razali with metric number 277847. For the fourth presenter, Nur Shamilia Zaida binti Zulkifli with metric number 280492. And for the last presenter, Nur Azira binti Arifin with metric number 270893. Next, I will pass to the first presenter to continue the presentation.
Hi everyone, my name is Nur Huda binti Jaafar. My metric number is 280535. I will present about question 1, which is the summary of the background fact for this case. The parties involved in this case are Bank Pembangunan Malaysia Berhad as the plaintiff and two defendants who are the loan borrower guarantors, namely Ibu Kota Realty Sdn Berhad as the first defendant and Loh Chiat Hong as the second defendant. In this case, Ibu Kota Dakchai Iron Pipe Industry Sdn Berhad is a borrower for the two facilities that have been borrowed from the plaintiff. There are two facilities borrowed from the plaintiff. The first facility is term loan facility, which amounted to RM75 million, while the second facility is a credit facility, which amounted to RM55.48 million. Moreover, the second facility has been divided into three divisions, where the first are term loan 1 amounting to RM22.28 million, term loan 2 amounting to RM15.2 million, and revolving credit amounting to RM18 million. Among the matters that have been enriched or mutually agreed in the security document for the first facility are the effective cost of fund (ECOF) rate, all interest payable such as interest during the grace period, the effective rate for the interest payment, and any unpaid interest, the principal and the interest on any principal monies for the time being secured, including capitalized interest. On 31 January 2017, the borrowers for the first facility and second facility, Ibu Kota Dakchai Iron Pipe Industry Sdn Berhad, was sued by plaintiff solicitors to pay all outstanding payment. Upon receipt of such notice of demand, the borrower also does not dispute or challenge any of the errors or the amount of payment that they need to pay for plaintiff. After that, on 16 March 2017, plaintiff solicitors also issued a notice for the termination of use of the first facility and second facility, along with a notice for outstanding payment. From this notice, the defendant and the borrower also do not dispute or refute any of the statements that have been stated by the plaintiff, which they are failing to satisfy the demand made therein. As a result, the plaintiff finally won in the Court of Appeal order to obtain a judgment, namely CA judgment, between borrowers and guarantors, which is Loh Keat Chong, where LKC is also a D1 affidavit. However, the CA judgment was opposed and denied by the deponent for D1 affidavit, LKC, in which they disagreed the existence of the CA judgment against them. Therefore, several court decisions must be rendered in this case to ensure that justice is served to all parties without bias.
Assalamualaikum, Doctor. My name is Nur Shazwani binti Muhammad Nizam and my metric number is 280598. Now I will talk about the second question, which is the issue that raised by the defendants. The first issue is it is demand and termination notice. Plaintiff is obligated to describe the principles and method of computation as required by law. Defendants claim that plaintiff did not present adequate proof of the ECOF rate, principles and computation methods. This is pointless and irrelevant argument. Federal Court wrote in Dream Property Sdn Berhad versus Atlas Housing, it is the common character of businessmen to immediately refute any suggestion they mention to him, including in letters, and not to let it remain. Next, for the second issue is, defendants state that plaintiffs changed the ECOF rate without their permission or knowledge. The base lending was lowered by plaintiff from 6.75% to 6.15% per year, as communicated to the borrower in a notice on 2 September 2016. Prejudgment interest was properly denied by the High Court but reversed by the Court of Appeal because it erroneously assumed that no interest would be payable. And for the last, third and fourth issue is, it is about to recoup all money owed or the first facility and the second facility. Plaintiff has filed suit against defendants and Wong Yik Bank Berhad. They asserted that plaintiff's liability for the defendants should be allocated proportionally to the various securities in its possession and distribution. Plaintiff and BPMB have agreed that the corporate guarantor will be responsible as though it were a primary debtor under certain conditions. That's all from me. I'll pass to the next presenter. Thank you.
Hello doctor, my name is Nurul Huda binti Razali. My matric number 277847. So I will continue with the question number 3, which is, does the plaintiff have the right to enforce the guarantee provided by defendants due to loan facility being in default? So, based on the issues that arise, yes, plaintiffs have the right to enforce the guarantee provided by defendants. This is because for the first facility executed by the defender, guarantee is in addition to and not in substitution of any other rights or securities and may be enforced without first having resources to any other securities. After that, others executed by the defender about the first facility, which is the bank, shall be under no obligation or liability to marshal in its favours any security or any of the funds of assets which the bank may be entitled to retrieve or upon which the bank may have a claim. In addition, in second facility, there have a liability as principal debtor which is guarantor shall not be discharged, nor shall its liability be affected by anything which will not discharge him or affect its liability as if it were a principal debtor. This corporate guarantee is in addition to and not in substitution for any other rights or securities which BPMB may have under or by virtue of the terms of the facility agreement or otherwise howsoever. In addition, others executed by the defender about the second facility, which is guarantee, shall be in addition to and shall not be in any way prejudiced or affected by any collateral.
Hi, Assalamualaikum to Doctor. My name is Nur Shamila Zaida binti Zulkifli and my matric number is 280492. For question number 4, my opinion is the defendants do not have the right to contempt plaintiff when the plaintiff failed to inform the defendants on the changes of the rate which they claim that the changes were outside of their knowledge and consent. It is because plaintiff through its notice had told the borrower that plaintiff's base lending rate or base financing rate effective should be at 6.75% per annum, which is equivalent to plaintiff's ECOF rate. Plaintiff also has provided the details about the changes on the ECOF rate in its affidavit. No further notices to borrower on the changes of ECOF rate after plaintiff's notice because of the first facility and second facility already terminated. Moreover, this is plaintiff's right to change the ECOF rate and this has been agreed by respective security documents with the borrower which are first facility and second facility. The first facility is the TF facility agreement pursuant to clause 5.5 and second facility is the facility agreement pursuant to clause 3.5 for term loan facilities and revolving credit facilities. Therefore, my opinion is defendants do not have any right to challenge the terms and conditions that have been agreed between plaintiff and borrower that shown in the TF facility agreement and the facility agreement for term loan facility and revolving credit facility. The defendants did not know about those two agreements. Based on the documents agreed to by plaintiff and defendants, I believe the defendant's responsibility for the first and second facilities should not be impaired, lessened, discharged, or impacted by any change of revisions to the ECOF rates from time to time. Whether or not the defendants agreed to it or were aware of the alteration or revisions, any fluctuations in the ECOF rates will bind the defendants. Unless the defendants can establish apparent mistake, the plaintiff's statement of account as of 31st January 2022 is irrefutable evidence against them. In this case, the defendants have failed to demonstrate any evident mistake in the statement or to dispute the amount included therein. The defendants' objections to the statement are merely denials. Both guarantee documents provisions and unambiguous, and the defendants are obliged by them. The same should be upheld by the court. In the circumstances, the defendants claim that plaintiff neglected to tell them of changes to the ECOF rate that were outside of their knowledge and permission does not warrant a trial. Thank you. That's all from me.
Hi, my name is Nazira binti Arifin and my metric number is 270893. So for the last question is to explain the type of guarantees for defendant 1 and defendant 2 and their liability as principal debtors. The type of guarantees for defendant 1 and defendant 2 is the corporate guarantee. A contract known as a corporate guarantee is one in which a debitor and a corporate body or individual are both parties. The guarantor accepts under the agreement to assume liability for the debitor's obligation. This guarantee will outline the terms of the loan as well as who will be held accountable in the event that the borrower fails. The three major parties in a typical corporate guarantee are the guarantor, who is the person that promises to execute the legal duty by paying off the loan if the debitor is unable to do so. Next, the party who is given the loan is the lender, and lastly, the borrower who accepts the funds and is liable for repaying the loan is known as the debitors. So, based on the case study, the Bank Pembangunan Malaysia Berhad as a lender has issued a suit involving the loan facility provided by the bank to the borrower, which is Ibu Kota Ductile Iron Pipe Industri Sdn Berhad. This is because the borrower has failed to pay the loan, causing the bank to enforce the guarantee against its defendants, which is Ibu Kota Realty Sdn Berhad and Loh Jiak Hong. In addition, the corporate guarantor also assume liability as the principal debitor, which means that the corporate guarantor will be responsible for the sum guaranteed, and it is an agreement between the corporate guarantor and Bank Pembangunan Malaysia Berhad, but without affecting the borrower's obligation. That's all from us. Thank you.